Okay, remember the public does everything backwards. The only reason an attorney should be relieved on the case is because of a dishonor. If there's been a dishonor by his own client, there's no way that that attorney can help a client who dishonors him. Well, absolutely not. Now, when an attorney puts in a motion to be relieved, he's put it in, but he's only going to be ambiguous as to the conditions for the relief. He's going to say, oh, we don't get along, or whatever. He's not going to say, my client hit me over the head with a baseball bat and threatened my life, and is going to kill me if I put in another motion. So when the lawyer puts in a motion to be relieved of his job, the court must assume, it's equity, that there's been a dishonor and that this is a colossal waste of commercial energy having these two coupled together. Now, if you don't rebut the presumption which is set in the court, you've agreed. Therefore, the counsel is taken away because it's assumed and presumed you're in a dishonor. Now, would the court have to reappoint more counsel if the evidence is on the record that you're continuously in dishonor to counsel? No, whose fault is that? Is that the court or is that yours?
Well, that's individuals.
So you've just nullified the requirement of the necessity of counsel. Look, we'll appoint another counsel as soon as you can get along with them. We'll put a counsel in the back there, and if you want to go talk to them, we'll supervise you so you don't hurt them. Or whatever. So, what you need to do as a witness is, your attorney sent you the paperwork, so you got to accept it and return all the paperwork he sent to you back to the attorney. That's your procedure. Now, when you send the paperwork of the motion to be relieved and all the documents back to the attorney, accept for value, return for value, settlement, closure, whatever, you've got to put an affidavit in support of negative averment. I do not believe I did any act or action knowably or willfully to cause any dishonor to the attorney.
Right.
I don't believe I requested the attorney to dishonor any other party in this action. I don't believe I requested the attorney to do anything that's illegal. I don't believe I requested him to do anything unlawful. As a third-party witness, I observe that if the court, for any reason, removes him from the case, I don't see how the defendant has any counsel to assist him in this matter for a remedy. Further, the witness saith not.
Then how does the court relieve that attorney of the public side?
Because it believes everything you said, which means they've got to throw him off the case as a commercial entity to give you the remedy you just asked. So they discharge him, but he immediately comes back and says, I'll be happy to serve. And I won't charge you anything because you're an honorable man. And you got to go, love you, lawyer, but I'm not asking you to do it for nothing.
I can see how that will work.
You understand?
I understand.
It's totally backwards. And it's perfect. Now, if you're in dishonor and they grant the motion based on a dishonor, he's been discharged on the liability side and you're screwed. But if you do everything right, it's what they do, not what they say. And if you do everything right, the judge is going to go, we can't discharge this guy and keep him off the case, or we just dishonor this guy. So we'll fire his ass from the commercial side and he'll serve, and says, just like in Genesis 23, brother, you're such an honorable person in our land, we'll give it to you for no cost.
So when you respond to the motion of the attorney to be relieved, it is also not only served to the attorney, it's correctly served to the court and served to all principal parties.
Absolutely. So now, procedurally correct,
right,
commercially correct, morally correct, the court's working with you and you're working with them, and the patriot that gets the Monday night, never gets the Monday night class, but hears that you should probably work with an attorney, is going to say, nah, whatever you do, don't buy into the mumbo jumbo coming out of right way law.
And I never.
Absolutely perfect.
And I don't speak the mumble jumbo.
I
so
try not to myself.
It's a tough language.
It really is. Okay?
Thank you very much.
But you see what
That's
you're doing
good
there.
work. Yes,
And I
this
mean,
is excellent.
there's not one person in 1,000 that has eyes to see that or ears to hear that, because they're going to go, well, let me get this straight. They just fired your lawyer. Yeah. So what's the problem? That's what you were looking at. He's no longer on the commercial side. Well, then, duh, how's he going to help you? Well, because he said he was going to serve you.
And those are the small idiosyncrasies that we're missing.
Absolutely.
And I really appreciate it, because I had to share that. I had too many people coming. We were putting pieces together, but I think that will allow me to put more of it together so I can respond.
Very good. Okay, thanks. Joe?
Yes, I hear a lot about private and public and straw man and living man. I'm not sure I got the right idea on this, so I'm going to throw out some musing, some things that I've been thinking about. I was wondering about I guess you'd call it the attributes of a straw man versus the attributes of a living man. For example, does a straw man have a picture? Can you get a picture of a straw man and a picture of a living man? The question has application as far as the driver's license goes. Whose picture is on that? If that's a straw man's picture, interesting. If that's a real life picture, then have they captured the real life person and made him obligated by virtue of his picture to be on that license?
Joe, can we use common sense?
Let me get done, and then you can correct me.
Okay. Go ahead.
The next thing is, does a straw man have fingerprints? In the state of Ohio, there's a profession that they recognize as a private investigator. I'm not sure if private is private or private is public in this case. But to be a private investigator in Ohio, you have to be licensed, which includes your fingerprints. Again, who is going through this licensing procedure? Is that the straw man or is that the real man? And then the last thing I wondered about is, does a straw man have a signature? Well, like I said, I don't fully understand this, but you can get where I'm looking at. I want to identify, I want to see this straw man guy. And I want to see the real life person. If I can't differentiate, does that mean that we really have a difference? I'm open for comment.
Now there he stumped me. We need some mumbo jumbo. Let's do it. Okay. Joe, we got you there, you're living. We got Caleb here, he's totally dead. Okay? Now I'm going to take out my brownie Hawkeye because I don't like these new electronic stuff. And I'm going to snap a picture of you, you're living. And then I'm going to take the same brownie Hawkeye and I'm going to take a picture of Caleb and he's dead. What shows up on the picture both times? If Caleb is dead, is he not going to appear in my brownie Hawkeye photograph? So am I taking a picture of the living or the dead? We're taking a picture of the dead. How does the living show up on the film? In some cases with Caleb, whether he's still with us or not, it's going to be hard to tell whether I took the picture of the living or the dead. It's going to look the same. Except some days his eyes are open and then we're going to be really confused that they just forget to shut his eyes when he dies. The point is, when you die and you're no longer living, did your fingerprints evaporate? Or did they stay with the dead? The body is the vessel, it's the dead. They're taking the fingerprints of the dead, they're taking the picture of the dead, and the only thing that's causing anything to happen is the animation of the living motion of the arm with the writing instrument to give a signature. And the living entity motivated the fiction arm to give a signature, but the picture is of the dead.
Well, if it's a picture and fingerprints of the dead, why do they come and arrest the living man for not giving them what
They're
he's
picking up
supposed
the body. They're picking up the dead body.
to? I'll have to think on that. I don't quite understand that.
Go think about it. Enough mumbo jumbo. More mumbo jumbo? Go ahead.
I was flipping through the TV the other night, and that show that's what's it called? The White House,
West Wing?
West Wing. And I didn't really watch that. I just happened to watch that moment there. Something exciting was happening. It seems like the president's daughter was kidnapped, or she just disappeared, and everything was chaos, and they were trying to find out what's going on. And the spokesperson for the White House came out, and she had to give the reporters something, because it's breaking news already. So she comes out, and the first things out of her mouth were, there was an attack on the principal.
Right.
And I'm thinking, what does that
Who
mean?
is the president's daughter? Who does the president's daughter represent? Let's put it that way. The people of America. God, she was kidnapped, huh? I wonder who took her. I think the bankers got her, maybe. She's in slavery. Okay, so the president's daughter, the people of America, i.e. the civil side of the church, was kidnapped. And they said it was an attack on who?
The principal.
Oh, aren't the people the principal? What part isn't the West Wing telling you is going on? That is, if you're into stories and metaphors. So what is your question?
Well, she didn't come out and say the president's daughter was...
Has nothing to do with the president's daughter. They're trying to tell you the people have been captured. It's a metaphor. If you think it's a public entertainment, it's that for the sheeple.
Another show, Law and Order.
Which is equity and disorder and chaos. Go ahead.
I was listening to the channel the other night on that. There was a part somewhere, I can't remember, but I remember the person stated, I think it was the attorney, the secretary of in the office, said that they were released on their own reconnaissance.
Okay?
What does that mean?
That means that they bonded their own action and they were the creditors in the case if they can keep it. In other words, they honored it. Yeah, same thing in Bob's case. He was honored. He was given a lark. So. Yes, sir.
I happened to listen to Shortwave last night. Tom Valentine was on. And right after he went off, there was a guy that came on that was interviewing all these clerks in the court and all these sheriffs and everybody else, and getting all different kind of answers about Steve Maigret still being in jail.
Okay.
So he's sitting up there in jail, and this guy is putting them all on the radio, and each one is giving a different answer, and where the records went, and how come they disappeared, and this one says no, and this one saying yes. So I thought maybe somebody might want to look at this website. The website that he gave was attorneybusters.com, and I think you might find something in there about what's happening to Maigret. But they're really working on it, on that case.
Well, see, the whole problem with Steve Maigret's case back there when he was doing what he was doing and everything, it started out a land tax case. But very quickly it went into he was going to charge public officials with liens and economic things type case.
Remember that.
Okay? In other words, he was going to charge the public officials for doing wrong. Well, when you charge them, they've got the authority, they come back and triple charge you. Is that the condition he's in? So in reality, remember Genesis says it in a little bit different fashion in Genesis 4. When you attack them, they will attack you tenfold. So that's what's happening. See, he was still in a warfare. He was still fighting. He was the vampire clan trying to protect himself. Actually, he was a werewolf. He was the guy that was being attacked, he presumes, by the vampires. Or the other way of saying it is most patriots are now today terrorists because they're attacking government officials and they don't have license and authority to do that. Which is what the terrorist war is all about.
Another thing I think I wanted to take, you mentioned something about Jeff having some kind of a memorandum on something that you were going to bring in and state it to us.
I can't remember. If you get specific, let me know and I'll...
It was something on accepting for value and proof of claim, but it was worded differently, and you said it was very powerful the way it was worded, and it meant a lot the way...
How long ago was it?
About 3 weeks ago.
Okay.
4 weeks ago.
Pardon?
It might have been the same time that you talked about Gar Bradley, which you were going to talk about him again on the first part that we missed.
I'll go back and see if I can pick some of that up and see what I can find there. If I got something, I'll bring it in.
Okay, thank you.
Okay. A couple other things that are going on. In a lot of cases now, when we've been doing the acceptances for value, returns, and ask for settlement and closure, one of the things that's happening is the other side is coming back and they're like making re-offers. There have been some people in criminal cases, and they're asking for settlements and closures in these criminal cases and saying that they're going to use their exemption to discharge whatever the liabilities are, and they're asking for settlement and closure. And then the public comes back, and in a couple of instances we've had a prosecutor or somebody come back and do something like the following. Would you, in return for a guilty plea and no jail time, would you accept a guilty plea to a felony count, no jail time, just time served, and a fine of $2,000? Yeah, you're absolutely right. It is a redraft. Okay? Now, where does this look in the overall scheme of what's going on? And this is just a subset of bigger problems trying to do the resolution. Because they come back and they want to offer you something else again. Now, you can't argue with them. That's a dishonor. You've got to respond to it, or it's a failure to respond. That's a dishonor. So the question is now, you could do an acceptance. Now remember, if you do a conditional acceptance, that's not a resolution. So you can't do a conditional acceptance either, because that puts the draft back on them to whatever, and there could be changing circumstances there. So the question comes up when they come back and they'll say, tell you what, you plead guilty to a felony 1 count, we'll have no time in jail and fine of whatever, maybe probation. Is that okay with you? Okay. Now what always happens is, every time these people draft you, they tell you, we're going to give you door A or we're going to give you door B. The reality is it's unstated. There's always at least a door C, if not D, E, and F. But it's never stated in their offer. If you take door A or door B, you're on the liability side again, and you're probably in a problem, undoubtedly. What happens, remember a couple of months ago when we were saying, these are equity courts. They're going to bring charging instruments that's a little bit country, a little bit rock and roll. They've got a little bit of fact and a little bit of assumption, presumption. which means that the charging instrument is like law and equity. True facts that you can't disagree with, and assumptions and presumptions to conclusions. You don't want to attack the facts, that's a dishonor. But you want to overturn the assumptions and presumptions by bringing new evidence or a new issue. In common law pleading, it's called confession and avoidance. And in confession and avoidance, the confession is we agree with everything you've done here. That's true fact. And we're not going to argue the assumptions and presumptions and conclusions, but we're going to bring some more facts which are going to, in and of themselves, rebut those assumptions and presumptions. So the way you must respond to everything they do is agree with the solid rock basis of what they're doing, and then add something to it. And if you fail to add to it, you're screwed. But if you add something to it, it opens up the visibility to door C or D, which is going to give you a different result. Okay? Now, the thought has occurred because remember, in Ben's case, when he's in sentencing, the judge basically said, look, the straw man's going to get 17 years. Ben, we like you. You could go home tomorrow. But then basically the judge says, well, we don't have an agreement between you and the prosecution, so you guys hammer this out. Okay? What you have to do is accept where you're starting from and then add something or go with it. And you can't fight it, whatever's offered, because if you do, that's a dishonor. So what about the concept that if the prosecutor says, if you will plead guilty to a felony 1, there'll be no time in jail. Maybe the guy's been in jail for 5 or 6 months. There'll be a fine of, who cares, immaterial or irrelevant. Maybe he's going to say there's going to be probation. Will you agree to that? Okay? Now, if you flat out say yes, and he goes, okay, let's go into the judge. You're going to go into the judge, and the judge is going to go, do you agree to this? Da-da-da-da-da. Okay, everybody's in agreement. Fine. Sir, you can go home now. What's the problem with this agreement right here, right now, and the circumstances of that resolution? What's the problem? Huh? Well, it's not settled and closed because it's presumptively on the public side. How do we know it's not settled and closed? What's the evidence of it? How do you know? That's a conclusion of law. How do you know you're the debtor? Acceptance puts you on the right side of the issue, but how do you know that you did a liability acceptance instead of an asset acceptance? Well, yeah, you're going to get the $1,000 invoice, aren't you, for the fine or whatever you agreed to. How do you know it's on the liability side? Would everybody in this room agree to that condition? How many wants to plead guilty to a felony 1? When you plead guilty to a felony 1, how's that going to affect the straw man's life in the future? It's going to go on the record. What's it going to do once it's on the record? How's it going to destroy the straw man? What can he do from now on? No weapon, no voting, can't get a good job, always going to be suspect. Hello, who's the holder in due course of that record? The public. Is that on the liability side or the asset side? Liability side. Okay, what if you came back and said, I accept your offer, return your offer for value, and ask for settlement enclosure, and as part of the terms of settlement enclosure, I want to use my exemption as the offset of any charges, and I want the record sealed to the public and released to me. What is the record going to follow the straw man? It's sealed. It's on the private side. Did the prosecutor say we're going to keep the record public? No, he never said that, did he? That's door C. It's up to you, man. There's more doors than what appear to be opening and closing here. See, every time they make you an offer, they give you a semi-offer. You've got to add a term and condition to that without objecting and protesting to any of the things they brought. You want to plead guilty to a felony one? I'll plead guilty to murder 20 times as long as you're going to seal and close it. Because if it's sealed and closed and it's discharged with the exemption, has the public got an interest in it anymore? No, they better not use it. How's it going to affect the straw man vessel? It can't under the terms and conditions of the closure. What did you do to the terms and conditions that were offered to you? Did you argue with them? Did you object to them? No. You accepted them and then requested they add one or two more terms and conditions which you desired, which would not dishonor the court, not prejudice any of the parties, but end up being to the advantage to you on the private side at some later time. Yes.
The conviction is still sealed.
It's still sealed.
But it's still a conviction. See, they have to have that.
They got to have the conviction.
They have to have the conviction. And some people don't understand that. That's a win. But you have to seal it.
They win, you win.
That's right.
You give
That's
them,
what the
they
acceptance
give you.
is. You may have missed that, but the acceptance was, I accept the conviction. Here are the terms of my acceptance.
Did the Messiah accept the death on the cross? Had to be done, didn't it? But He added something to it. A resurrection. No problem. You understand what's going on? So every time these prosecutors come back and tend to offer something, or the opponent in a civil case tends to offer something that looks like it's something you can't agree to, you got to think in terms of, look, what they're offering has got to have a trap door to it. If you figure out what the terms and conditions are to define the trap door, it will nullify the evil effects that you didn't want to have by agreeing to what appeared to be offered to you. You understand where we're going? And it comes right in the pattern of how you resolve this. See, they're not in dishonor to you by coming back after all you've said and said, hey man, would you plead guilty to a felony one? Just go and go, that guy just dishonored me. I told him to settle and close it. How is that an honor? He gave you the ability. Just add a little bit to it and get your remedy, man. Use your brain. Instead of going to war, go to peace. Yes.
Can you go back, if you didn't pull your exemption first time, can you go back and redo it?
You can always correct a mistake because no matter what they've done, whatever it is still in escrow because they can't close anything until you allow it to be closed by the exemption on the private side. So everything is still open or in escrow.
Okay, I know of a particular case where the individual was sentenced. He hasn't done his sentence. He paid it with his phony money.
What phony money?
With his check.
What
Credit
check?
reserves.
Open account or closed account?
Open account.
Okay, so he's paid in liability.
Right.
So he's chosen to be a slave. Okay, go ahead.
Not knowingly. He didn't know.
Okay.
So, let's say his sentence is going to be up in, he has to do his sentence in November.
Mm-hmm.
Can he go back and make his exemption now?
Yeah, absolutely. Why are you put in prison? What do they say you're doing when you're put in prison?
Because you haven't fulfilled your liability?
You're paying your debt to society when you're in prison. So what's the purpose of prison? To balance an account. Well, hello? Why don't you tender them the consideration before you have to go in and work it off?
To do your time in purgatory so they can let you out when they want.
Well, prison is the purgatory. But if you use the blood of Christ, why do you need purgatory?
Correct.
It's already been discharged. Duh. Okay? Alright, so that was issue number 1 that I wanted to talk about tonight. Okay. Question. Which comes first, chicken or the egg? Really? Where do you come from?
Creation.
Huh? Yeah, I did way back at one time. Yeah, okay. Here's where it's important. Let's say IRS has been on your straw man's case, and IRS has been writing you the letters going, gee, where the hell's your tax? You know, we haven't gotten any return from you from 1701, and we've been looking for it desperately, and it's got to be around somewhere. And you come back, and let's say that you're really up on all this stuff now, you're intelligent, you've got eyes that can see and ears that can hear, and you know that you can't write back and do stupid patriot things like, hello, don't you understand you don't have any law to tax people? Dumb stuff like that, okay? So you're smart, and so you write back across the letter, accepted for value, returned for value, what settlement and closure, here's my exemption account number, here's my signature to authorize you to do it, just settle, close this case, and let me know, and bang, it's out the door. Then you're really shocked a couple of weeks later to get another letter from them going, you still haven't filed your stupid return. Well, you didn't send a return back with your acceptance letter, did you? So is the fact in their second letter true?
Yeah.
Absolutely. So now you're really getting honked off at your servants because they aren't paying any attention to what you're telling them to do. Settle and close the account and stay out of my life, and you gave them the number and you gave them the authority and the signature, and they're going, look, we're going to give you 30 days in order to file your return, and if you don't file it, we're going to put in a substitute for you or something or other. So you accept that for value, return it for value, you once again tell them, okay, here's the exemption number, I'm authorizing you to use the exemption as the consideration to settle and close the account. And just for the hell of it, I'm sending you a bill of exchange that will authorize the transfer of the consideration, but I can't put the amount of money on that because you haven't told me what it is you're looking for, so I'm authorizing you to fill it in. And let me know when it's done. So things are going around. About 2 months later, you get a letter from some other person at the IRS that says, well, that really does it because you still haven't filed your return and we've given you a lot of time and now we've worked up a worksheet with the information that we've got and we're proposing that you owe us $10 million in your taxes. And we want you to sign this sheet and return it if it's agreeable to you and keep one copy for yourself and whatever. So you're going, oh, these people are not listening to me. You do an acceptance for value again, return for value. You refer them back to your other letters. You're telling them to settle and close the case. It goes back to them, and then a couple of months or so later, you get this notice that here is the proposed assessment. And if you agree to it here, whatever. So you're accepting that for value, returning it for value, sending it back again, and you're going, geez, this process is not working. No matter what I do, they just keep going on. It's like whatever. They won't listen to me. So you've done the acceptance on the so-called proposed assessment. It goes back, and the next letter you get is a letter saying that either we've liened you or we intend to levy you. And you keep going, this is insanity. This is either supposed to work or it isn't. What's going on? Now, the question is, what comes first, the chicken or the egg? Okay? A lot of times, the first thing that one needs to get between the parties is the contract or the agreement. Agreed? Now the question is, once you get an offer and an acceptance, supposedly you've got a contract. So the first time the IRS probably said, hey man, where's your tax return and what we're going to do? You could come back and do the acceptance and supposedly you've got an agreement that if there's an obligation and duty there, you've accepted it. Now there's an agreement or a meeting of the minds of the party that we've got an agreement, tax offered, tax to be paid. Then you said, here's a blank bill of exchange. Let me ask you a question. Does a bill of exchange convey commercial money? No, there isn't any. Okay? You wrote out a blank bill of exchange, and you sent it to the IRS and said, use this for settlement. Have you sent the consideration or whatever to discharge the obligation? No. When would the bill of exchange be good? When there is evidence of an existing debt. Now the IRS has been saying, hey man, we're looking for your return. What did they want you to do on the return? They wanted you to produce some facts and figures to evidence the debt by agreement of the parties. Okay? Now, you didn't give them any information. So in reality, can the IRS come up with an invoice? No. Why can't they come up with an invoice? Because they can't write the invoice of debt for you. If they write the invoice of debt for you, they're charging you. They're in violation of James 4:11. They can't charge anybody. They're bankrupt. They can't charge anyone. They can't create a debt. So not only do you have to agree into a contract with them, you have to agree to the debt. Which comes first, the chicken or the egg? Who authorizes them to bill you? You or them? You've got to authorize them to bill you. Look, whoever is first is creditor. Whoever is second is debtor. Because the created can never be greater than the creator. Now, if somebody's coming in with a conditional acceptance for value, and I've talked to a lot of people that were doing conditional acceptances for value, and they said to the IRS, or they said to traffic, or they said to the zoning board, if you can prove your claim, I will pay. It can't be done because they can't prove a claim. Because if they proved a claim, they'd come first and they'd be the creditor. Then you'd be the debtor. If they produced a claim, you couldn't pay it because only creditors can pay. Debtors cannot pay. So number one, if you're playing the game, I will agree to pay my traffic ticket if you can show where you have legal and lawful authority, blah, 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 to do what you're doing. I will pay my income tax if you can show where you have a law, if you can show where you have truth on your side, if you can show where there's a claim, I'll pay that ticket. Beat, wrong. You're asking them to be creditor. I thought we were supposed to be the sovereigns and the creditors, not them. So you don't ever conditionally ask them to do anything because you're asking them to be what they can't be, a creditor. You're asking them to come first and I'll come second. The whole concept of being a sovereign is you've got to learn to come first. The grade schools and the public schools have taught us all to come second and be debtors. Don't do anything until your teacher tells you what to do. Don't do anything until government tells you what to do. Because they're the creditors and you're the debtor. Duh! That's been the problem. So the IRS comes back and they're trying to be honorable and said, hey man, where's your tax return? Hey man, you show me where I have a liability and I'll file it. Beep, that's wrong. The first thing you did right, you said, hey, I fully accept that, I return you, and I asked it for settlement and closure. Okay, you authorize them to agree they've got a contract with you. The next thing is, see, when you go into a restaurant and you sit down for dinner, when you go to the waitress and she sets you at the table, haven't you agreed to a contract? Yes. Okay? Now, when the waitress brings the bill, does she want you to agree that the bill is okay? If you don't agree the bill is okay, how can they ask you to pay it? Same thing with the IRS. Just because you've got a contract doesn't mean that the IRS can settle and close the contract until you also mutually agree to the amount of the bill and you authorize the bill. If you authorize the bill, then the IRS can say, okay, here it is. Now, the bill is their consideration in the contract. So you not only have to agree to the contract, you've got to agree that it's acceptable as their consideration. Once you've agreed with them and they now have given you the bill because you authorized them to give you the bill, is there now a debt? Absolutely. Is the debt pre-existing to your bill of exchange? And is the commercial energy in your bill of exchange pre-existing? So you can only have like go against like. The energy in your bill of exchange is pre-existing. It's a prepaid account. It only works on debts that are pre-existing. You can't use the energy of a bill of exchange, which is a prepaid cash item, against a potential or a future debt. It doesn't yet exist. It's not in the same plane. So when you keep writing these letters to the IRS, and the IRS just keeps coming on and on and on, they're just moving ahead, inching closer and closer to where you will authorize the debt invoice. Then your bill of exchange becomes relevant to pay it. What happens if you pay a bill before it's due? If there's energy there, what if you use an instrument to pay a debt that has no energy yet because it's not energized until the debt exists? There's nothing to offset it with yet. You understand? So it's not the concept of our process that's wrong. It's our understanding of how it goes out. For instance, I've had a couple of people that started doing stuff with the IRS several years ago. And they were doing the conditional acceptances for value. IRS sent them something and said, where's your tax return? I promise I'll pay every penny on proof of claim, conditional acceptance, on proof of claim that I have any liability. Well, the IRS has been conversing with these people for about 3 years now. And they keep going, but nothing's been resolved. This isn't working. I'm going, because you're using conditional acceptances. See, when you're using conditional acceptances, what they're doing is you're saying, I'll do this if you do that. I'll do this if you do that. I'll do this if you do that. What's the problem here? They can't ever do it. Because if they can, they would be sovereign and you'd be a slave. And they're not about to go into sovereign slave. There was it a movie? Was it a story? I think it was a movie. Come to me in a minute maybe what it was. There was a character in here, and this character, how was he doing it? He was involved in a process, and he said to the other side something about you've been, oh, I know what it is. It's Matchstick Man. Absolutely. Matchstick Man is about a confidence man. And a confidence man, a flim-flam man, is called a matchstick man. What is that? Isn't that like a straw man, a matchstick man? Why would a con artist be called a matchstick man? Because the character he portrays to the victim is not the person that's really there. It's a front to con the mark. So he's a matchstick man. Okay? Now, in this story, our hero, the matchstick man, has got a con partner, and they've been going around just taking a bunch of victims for penny any money. Every now and then, every couple of years, they go in for a big mark and make a big score. And Nicolas Cage, our matchstick man, has put away tens and hundreds of thousands of dollars that he's conned out of all these people. He's got it in a safe deposit box at a bank. Doesn't have it in a bank account where it can be searched. And he's got it in a piggy bank at home. Okay? Now, all of a sudden he's introduced to this young lady, 14 years old, that is his daughter, surprise, never knew he had a daughter, from the marriage with his wife when they broke up 14 years before. And so he's going, I got a daughter. I got to be good. I don't know why, but got to be good because she's a sweet young lady. She's got to think good things about me. I can't be evil. I can't be mean anymore. So what does a con man do when he's got a 14-year-old daughter, Angel, who thinks he's God and a wonderful person? Well, she finds out she calls him a con man. He says, con artist. And at one time she says, do you like doing what you're doing? He goes, no, I really don't like what I'm doing, taking this from, all these people. She says,